Hello there. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. And today I want to talk to you about what is a blind trust. So trusts are typically set up for the benefit of a trust maker's loved ones, a charitable organization, or a third party, with the trust money and property being distributed to the beneficiaries upon that trust maker's death. But there are situations in which a person may want to set up a trust to be used during their lifetime for their own benefit, to maintain privacy or to avoid a potential conflict of interest. And in such cases, what we call a blind trust might be appropriate. So no state or federal laws require the use of blind trust, but they can be an effective tool for complying with laws that prohibit insider activities. Blind trusts are also used by a lot of those lottery winners who choose to remain anonymous, and they don't want everyone to know that they've actually just won this big winning. So let's talk about how blind trusts work. The blind part of a blind trust refers to the idea that the trust maker or the grantor, the person who establishes the trust, remains in the dark about how the trust money and the property are managed. Although they may lay out general parameters for the trust, such as investment goals, prior to creating it, once the trust is formally established, the trustee, the person who is in charge of controlling all of these assets, has full discretion on how to handle the trust holdings and has no communication with the trust maker. The beneficiary of a blind trust also has no knowledge of what goes on with the trust. However, in most cases, the trust maker is also the beneficiary. That is, the trust contains their personal money and property, and the trustee manages that money and property for the benefit of the trust maker, also the beneficiary. Now, this trust maker beneficiary has no knowledge of or control over the activities of the trust. A blind trust differs from a normal trust in several ways. The biggest difference is that in a non-blind trust, the trust maker has discretion over trust money and property. Often they give explicit instructions to the trustee about how to run the trust, such as when and how to make distributions to that beneficiary. Usually the trust maker and the trustee consult each other, and in some cases they are in fact the same person. And while the beneficiary may be at the trustee's mercy as far as receiving trust distributions from a blind trust, with a non-blind trust, the beneficiary may be in contact with the trustee and may be aware of all of the trust activities. Blind trust can be irrevocable or revocable. A trust maker has the authority to modify or terminate a revocable trust and take back control of the accounts and property upon termination. An irrevocable trust cannot be modified or terminated by the trust maker. In other words, once the trust maker places money and property into an irrevocable blind trust, the trust maker permanently gives up control over that money and property. So let's talk about blind trust and public figures. Now, viewers of that television show Billions may be familiar with blind trust, thanks to the character Chuck Rhodes. For anyone who has not seen the show, Chuck is a New York prosecutor known for his flawless record of winning insider trading cases. Chuck put his investments in a blind trust managed by his father to show the public that his actions as a public figure will not be influenced by his personal financial holdings. This is a tactic employed by real-life politicians as well. While no state requires public figures to use a blind trust while in office, most states and the federal government have laws that require government employees to recuse themselves and disclose when their public duties may affect their financial interests. These laws are intended to maintain trust in public institutions, helping to defend against legislative self-dealing or the perception of it. Now, blind trusts are just a workaround to real or perceived conflicts of interest. A public figure can place the money and property that might create a conflict of interest into a blind trust and turn the money and property over to an independent trustee. The official can then claim that they do not know how their actions in office will affect their private financial interests because they have no control over those interests. Now, a dozen states have laws that regulate blind trusts, and these regulations must be followed closely. Federal ethic laws also have rules about what qualifies as a blind trust and how it should function in order to comply with the law. Blind trusts are not just for government officials. Conflicts of interest can similarly impact officers, directors, and others who own shares in a company and have information not available to the public. Ownership of these shares can call into question whether a corporate insider is acting in the best interest of the company and its shareholders, as federal financial law requires them to, or in their own interest. The Securities Act restricts the sale of shares owned by corporate insiders for as long as they are affiliated with the company. Publicly traded companies usually only allow insiders to trade company stock during what is called window periods. A blind trust set up during a window period can be a mechanism for avoiding these trade limitations. The trustee of the insider's blind trust is given guidelines for selling company stock, and the trustee is then free to execute this plan without running afoul of insider trading laws. So while politicians and company insiders may use a blind trust to avoid conflicts of interest, a lottery winner or person who receives a financial windfall may use this type of trust for a different reason, and that's for financial privacy. Let's just say that you're the lucky winner of the billion-dollar Powerball lottery. As excited as you are to spread the news and raise the big cardboard check on television, you decide that you want to remain anonymous. Now, there's plenty of reasons to keep a low profile, whether it's reporters or scammers or harassment, or just requests from friends and family, just to name a few. But not all states allow lottery winners to actually remain anonymous. If you do not live in one of those states and you want anonymity, then you can use a blind trust to protect your identity. However, blind trust is a bit of a misnomer in this situation. It is just a regular trust that uses a name other than your legal name. You retain control of the trust and its money and property, but you are blind to the public because the trust is not easily linkable to you. Establishing a blind trust can be complex. Depending on its use, there may be federal and state laws to comply with, including rules related to conflicts and disclosures, reporting requirements, who may serve as the trustee, and allowable communications between the trustee and the beneficiary. Now, blind trusts are set up for very specific reasons, and for them to function as intended, they must be set up carefully. If you want to prevent conflicts of interest or maintain privacy, it is vital that you work with an experienced estate planning attorney to ensure the accuracy and the validity of your blind trust. So I want to thank you all for watching this video on blind trust. Please like and subscribe our page so you can follow other videos regarding estate planning to help you better understand the options that are available to you and your family. I'm Attorney Kelly Longtin, founder of Kelly Longtin Law.